turn it over to the staff, to the Regulation and Discipline Committee. I know that I was a staff for a long time, but it's now, I've passed the baton to Lisa Chavez.
Okay, I'll take roll. Good morning, everyone. Chan? Cisneros?
Here.
De La Cruz?
Here.
Duran?
Here.
Ganong? LeBron?
Here.
Pertula?
Here.
Slig?
Here.
Sol?
Here.
Stalling?
Here.
Am I not on rad?
You are on rad. You should.
I'm here.
Sorry, Sol, yes.
Not only are you on rad, but you are rad, Mark.
All right. Well, with that glowing recommendation from Ruben, we will get started here. So the first item on the agenda is closed session. We are going to move the closed session to the end of today's agenda. So Jeff, I don't know if you're on the line right now, but we will most likely take that up in about an hour. So hopefully that works for you. And we anticipate that closed session will take approximately 20 minutes. So we will go then into our open session agenda, and I will start things off by making a call for public comment and ask if any members of the public wish to comment on the agenda to please raise your hand and notify staff of your intention to do so. All right, staff, do you see anybody wishing to make public comment?
We have two hands raised.
Okay.
Three now.
Right. Is Lisa able to let them in, or is that a different staff member?
I'll partner with Lisa on this. Lisa, would you like for me to keep the time on the public comment?
Yes, please.
Okay. So Chair, if it's okay, I can open public comment to the first speaker, and we'll notify the speakers that they'll have 3 minutes to make public comments.
Sounds good.
All right, we're going to start with the first hand that I see raised. It's Aaron Joyce. Your microphone will be made available to you in just a moment, and you have 3 minutes. Thank you, Ms. Joyce.
Great. I appreciate the opportunity to come and make a public comment to the Regulation and Discipline Committee today. And I'm speaking not only on behalf of myself, but also for the Association of Discipline Defense Counsel. Myself and Jean Shaw are here to talk about the changes that are proposed with respect to Rule 5.137. And I know that the materials, and you've seen our written comments, and they're part of your materials. But I think we need to highlight a couple points that have to be taken into consideration here. We've already made it very clear that sanctions are punitive. Sanctions equal punishment, and punishment is incompatible with public protection. There is a series of case law stretching back decades describing the discipline system and the actions of the Office of Chief Trial Counsel as focused on public protection. And that's the mission of the State Bar as it's currently constituted. This is a sea change in what is being expected to start imposing sanctions as part of discipline being imposed by a State Bar Court and the Supreme Court. And the implementation of sanctions in the discipline system is going to undermine the public protection mission of the system itself. It's undoubtedly going to make it much more difficult to stipulate to discipline when you're already talking about mandatory disciplinary costs being imposed. So this is not going to streamline the process. It's going to clog the entire process of trying to resolve discipline cases in State Bar Court, forcing many more trials, and all to punish lawyers, because sanctions are nothing but punishment. And all of those cases that talk about the discipline system as about public protection rather than punishment or punitive will be abrogated by the implementation of this rule. The due process for attorneys facing charges in state bar court have been relaxed. Why? Because of the fiction that this has only been about public protection, not about punishment. But that Band-Aid will be ripped off if now that the state bar court and the state bar's office of trials is going to be seeking sanctions. So in the context of the ad hoc committee that the Board of Trustees will be putting together on the fairness and equity in the discipline system, we're going to have to examine adding due process
Ms. Cha, you have 30
protections
seconds
for
remaining. Thank
lawyers,
you.
because they're going to be facing actual sanctions and punishment
Ms.
in
Joyce,
the
I'm
context
sorry.
of
Ms.
disciplinary
Joyce.
proceedings. That's not the direction that RAD or the state bar should be going, especially with the mounting numbers for backlog and the really dismal results coming out of state bar court, where the Office of Trials is pursuing charges that don't make any sense routinely. So we urge you to really re-examine Rule 5.137 and not implement mandatory sanctions.
Thank you. The next speaker is Jean Cha. Ms. Cha, your microphone has been made available to you. And once you unmute it, you will have 3 minutes to make comment.
Thank you very much. Good morning. I'm Jean Cha, Second Vice President of the Association of Disciplined Defense Counsel. So I'd like to address the concerns regarding 5.137. And the Office of General Counsel doesn't appear to take issue with the points that the ADDC has raised. And I think we can all agree that implementation of sanctions will increase the workload of the state bar prosecutors. It'll drive up cost of litigation and slow down the discipline process, creating several bottlenecks. As those sanctions are hefty and at $5,000 per count, it is, if there are multi-counts, it is going to be a huge point of contention. Implementation of sanctions will also exacerbate the impact of racial disparities in the discipline system. And this is a major concern because right now the state bar is trying to address those disparities, yet implementation of the sanctions is going to lose ground that we, and any progress that we make, and it will cause a major hurdle. The rule changes are, as Aaron Joyce said, incompatible with the state bar's strategic plan, because the adoption of the proposed rule undermines section 6086.13 and the state bar's strategic plan goal 2 to ensure a timely and fair disciplinary process is going to adversely impact both sides, the defense, the prosecution. All of us agree that the sanctions are going to be problematic. We ask that the board consider informing the legislature to enlighten them with these important policy concerns. Further consideration, which further supports the legislative mandate, be further tabled as these concerns are vetted. And it was tabled for 24 years. The implementation of it now is not appropriate, and it should be further investigated to see whether the impacts and the concerns that we have raised, which again, we see no dispute that these concerns are very real, that they be evaluated fully before sanctions are implemented. And my final point, that OGC says that the state bar will do nothing further regarding bringing it to the attention of the legislature, but we just want to clarify that the ADDC has sought the support of the board regarding these issues. And if the board's position is that licensees and the ADDC should go directly to the legislature, then we understand that that would be the next step. But we do strongly urge the board to please consider raising these concerns to the legislature on its own action. Thank you.
Thank you. Chair Stallings, I do not see any other people requesting to make public comment.
All right, thank you. We'll move now to the consent agenda. This is item 2, items A through C. And does anybody wish to pull any of the items off consent? All right, hearing none, I would entertain a motion to approve.
I'll move it. This is Duran.
I'll second. It's Jose.
Okay, first by Ruben, second by Jose. Lisa, please call the roll.
Shem, Cisneros,
Aye.
De La Cruz,
Yes.
Duran,
Yes.
Benong, LeBron,
Yes.
Petula,
Yes.
Saleg,
Yes.
Soul.
Yes.
Okay. Thank you.
I vote yes.
All right.
Broughton.
Yeah, let's make sure that Mark's on, on the list.
Lisa, you're missing me.
Thank you. Thank you. Sorry about that, Broughton.
Yes.
Okay, this motion passes.
All right, moving on to item 3A. This is the proposed new and amended state bar rules of procedure. And Suzanne Grant is going to be presenting on this. So Suzanne, are you on the line?
She is on the line. I wonder if she's impaneled or something.
She's
There she
just
is.
been promoted.
Thank you, Louisa.
Hi, this is Suzanne. Hold on, I'm just getting the video. Hi, good morning. This is Suzanne Grant from the Office of General Counsel, and I'm here to present on item 3A. This is a return from public comment for 23 proposed and amended rules, the majority concerning rules implementing Rule 5.137, which is the State Bar's new rule regarding the implementation of monetary sanctions. Outside of that, there was only one rule that was not about that. It was regarding a minor change regarding CSF. The proposal also included proposed amendments to Rule 5.137 itself. 5.137 does need to be approved by the Supreme Court. Amendments to that rule need to be approved by the Supreme Court. So it's kind of in a different category. So we received one public comment, and actually we heard from some speakers today that had submitted the public comment, the Association for Disciplined Defense Counsel. And that comment was largely summarized in the public comments this morning regarding the rule itself in terms of the sanctions and the punitive nature of the sanctions. And while we truly appreciate the commentary, the legislature has mandated that the State Bar implement these rules to implement a process and guidelines for implementing monetary sanctions. So the State Bar unfortunately doesn't have authority not to propose these rules and implement these rules. And as was stated this morning, it's been about 23 years since the statute has been promulgated that has mandated the State Bar to do so. So the State Bar is now fulfilling its statutory mandate. And to the extent there are concerns about the sanctions themselves, those need to be addressed with the legislature and not with the State Bar. There was also one other point since the rules had been made out for public comment that I wanted to bring to the attention of RAD that's in the materials. State Bar Court has been rejecting certain stipulations as well as rejecting proposed discipline that has included monetary sanctions based on the fact that the misconduct occurred prior to the effective date of Rule 5.137, which is April 1st, 2020. In the proposed language that we sent out for public comment of Rule 5.137, we proposed language specifying that the effective date of the imposition of monetary sanctions shall be April 1st, 2020. So that's whether or not the misconduct occurred before it, but whether the disciplinary proceeding had to have been commenced on or after April 1st, 2020. The State Bar has been rejecting stipulations in which the misconduct occurred prior to April 1st, 2020, because they view it as a retroactive application of Rule 5.137. it is not a retroactive active application because the statute, which mandates that sanctions can be imposed, has been on the books since 1993. So that's 27 years. So the state bar could have, but has been not recommending these sanctions as part of discipline for the past 27 years. The rule itself is merely a guideline. It's an implementing regulation, as the case law calls it. So the recommendation of sanctions that includes misconduct that occurred prior to that date is not a retroactive application of the statute. So we thought the language will hopefully clarify that. Our proposed language states that sanctions can be imposed for any disciplinary proceeding commenced on or after April 1st, 2020. So we are hopeful that will clarify the issue to when the sanctions can be recommended. But we did want to bring that to the attention of RAD to make them aware that State Bar Court was rejecting these stipulations that did have the misconduct occurring before the effective date of Rule 5.137. So in sum, we recommend that these rules, except for Rule 5.137, be approved to go into effect January 1st, 2020. The second resolution is Rule 5.137, as I stated, has to go to the California Supreme Court for approval. So we recommend the amendments to that rule, including the one I just stated about the effective date of the rule, that be recommended for approval by RAD and the board to be sent to the Supreme Court for approval. Any questions?
All right, thank you, Suzanne. Any questions for Suzanne? All right, hearing none, may I entertain a motion?
This is Jose. I'll make the motion.
Ruben, I'll second it.
All right, first by Jose, second by Ruben. Lisa, any further discussion before we take the roll?
Yes, Brandon.
Yes, Sean.
So yes, I just want to, in light of the public comment, I just want to note that the board will be discussing later the ad hoc commission on the discipline system that the board has already formed and is being in the process of constituting. And the policy argument that has been raised would certainly be a fair thing to raise with that commission. But at the moment we have a statute, and so we have to abide by it.
All right, thank you, Sean. Any further comment? All right, hearing none, Lisa, please take the roll.
Broughton,
Yes.
Young, Cisneros,
Aye.
Cruz,
Yes.
Duran,
Yes.
Anong, LeBron,
Yes.
Kutula,
Yes.
Blake,
Yes.
Sol.
Yes.
The motion passes.
All right, thank you. Moving on to item 3B, Office of Chief Trial Counsel, the hiring, retention, and inventory trends. And that will be presented by Melanie Lawrence, Acting Chief Trial Counsel. So Melanie, are you in the room and promoted?
Good morning.
There you go, good morning.
Hi. So I did want to talk to you about a couple of items today. One about our inventory and the trends that we've seen this year, just because it's a matter of interest, I'm certain, given the pandemic in particular. And also talk to you about recruitment and retention in the Office of Chief Trial Counsel. I understand that this is an item on RAD's work plan to actually make a report, so I'm here to do that as well. And they kind of go hand in hand, quite frankly. So I want to take you back to October of 2018, and that is when we launched the online complaint portal. And so from October 2018 to July of 2019, we saw an overall steady increase in the number of complaints. Despite the fact that we were taking complaints in online, we did not see a corresponding decrease for some time in the number of complaints we were receiving by mail. And so that had the overall effect in 2019 of really seeing a significant increase of our overall complaints. So at the end of year 2019, we saw 13,450 complaints. Now, when I say complaints, I want to be clear that what I'm talking about is complaints from complaining witnesses or other sources. It is not the entirety of OCTC's inventory. So for example, it does not include criminal conviction referrals, which we know increased in 2019 in particular because of the fingerprinting, as well as, for example, reportable bank actions. So it's not the entirety of our caseload, but in any event, starting in July of 2019, then we started seeing a slow decrease in the number of complaints, and taking us through then to March of 2020, when, you know, really there was mandatory teleworking that was going on, and a lot of the closures due to the pandemic. And since March of 2020, we have seen then a steady decrease in the number of those same complaints, and also complaints in other areas. So for example, the bank RA matters, we've seen less of those this year. So, you know, we are not surprised to have seen that decrease in March. I would have expected to see it level out a bit, but it has persisted over time, and it's not clear as to why that has gone on. It does seem to be related to the pandemic, but whether that is just because people are not attending to their legal matters, there's less business being done, for example, it's not really clear. So it's not really clear how long that trend is going to last. So in terms of what that has done to our overall inventory, the influx of complaints that we saw in late 2018 to mid 2019 really impacted us in the summer of 2019, so much so that what we saw was really an accumulation of those complaints in our intake inventory. As of the summer of 2019, we did not have additional resources in our office. And so what we did to try and address that inventory was we assigned intake reads to all of the attorneys in our office, regardless of their assignment. So that included, for example, managers, supervisors. I did 10 of them myself, so that we could move that inventory through. And while it's true that really the bulk of cases do close at the intake level, the fact is we still have a fair amount in any event which move forward to investigations. And because we deployed those additional resources in late summer of 2019 and early fall, what we saw is, you know, basically that volume of inventory then moved forward pretty much together into our investigation inventory, which had the impact of raising caseloads for investigators and legal advisors. And if you could think of it sort of like a snake that eats, you know, a large animal, the reality of that when it's moving forward is that it's slow in its process to digest, and especially because you have that volume happening at the same time. So even though we have seen the decrease in overall complaints coming in, the reality is that volume over time has continued to work itself out. So what that really means for the inventory by the end of December is that we'll probably look very similar to where we did last year. Again, despite the lower complaints overall, I really think that it won't be until 2021, maybe around the end of the first quarter of 2021, that we'll actually see the results of the decrease of the volume of complaints since March of 2020. So also thinking about the impact of the pandemic really on the staff and the productivity. Since February of 2020, we have actually been tracking the rate of productivity in our investigation inventory in particular. So one of the great things about Odyssey, it has its challenges certainly, but one of the really good things is that it allows us to accumulate and track data and see trends over time. So what what we have been able to do is look and see the rate of resolutions at the investigation stage from February 2020 to date. And so what we've seen is from February 2020 to literally when we started the mandatory telecommuting, which would have been in mid-March. Since then, we have seen a decrease in productivity persisting over time. Now, when I say that, it's not a decrease that is alarming, but nonetheless, it's a decrease that we can see in the average rate of resolutions per week over week. Now, we've talked a lot about why that is. And, the reality of remote working in the Odyssey world is that we can work all of our cases electronically. And so the staff has been able to still move cases pretty productively because of the electronic case management system. But anecdotally, some of the challenges have been that, and not surprisingly, it's been harder to get documents that we need, for example. So trying to get certified records from courts has taken longer than normal. Also, not surprisingly, respondent attorneys who are under investigation have often asked for extensions of time to respond to the allegations. Telling us, for example, that they don't have access to their files or their documents or even their office. And certainly that was true earlier on in the pandemic. So we know those kinds of things have an impact on the productivity, but it's really sort of hard to measure. And, the other thing is really that's immeasurable is the impact of a pandemic like this on people and their psyche. And the fact that, we have staff who are working at home, who are, maybe have kids at home or spouses at home that they didn't before. They're trying to share equipment, et cetera. Perhaps they don't have the best internet connection. And we know that those things also play into this, but they're not terribly measurable, frankly. So it's not completely surprising that we see some slowdown, but again, it's not an alarming slowdown. And we certainly have worked with staff to be flexible on work hours. We're going through the computer refresh as the rest of the bar is, so people are getting new equipment. And so they'll hopefully be able to have an easier time of actually doing their job. So with all of that, though, we do really have some silver linings with this pandemic, and that's really in the area of recruitment and retention. So you might recall that for 2020, the fee bill was increased, and part of that was to give OCTC additional resources to actually create a new team in Los Angeles. And we have been working on that despite our mostly remote working. So what we have done and what we started to do in early 2020 is to methodically post and recruit for the positions that it would take to build a team. And by that, I say that we didn't post them all at once. We took pieces. So we recruited for attorneys, we recruited for investigators. We have recruitment teams for each classification, and they've been doing all of the interviews and recruitment activities remotely via Zoom, and that's been going quite well. And with each position that we filled, then we put those new staff people on existing teams. Because what we knew is that we didn't want to create an entire team of all new people. That just really was not going to be manageable. So we wanted to get folks some training, and we wanted to, by the time we had the full composition of the team, we wanted to be able to move folks, some who were tenured, some who were new, onto that team to sort of balance it out. In September, we added the last position, and that is the supervisor position for that team. And we then moved the folks that we needed to move from the other teams to the new team. And we now have a full new trial team in Los Angeles, and we have had since September, and they're doing quite well. So with the new folks that we have hired, you know, we have been doing all of the training with these folks remotely. We have a training team, and we've had them for the last couple of years. It's a very seasoned senior attorney, as well as a very seasoned investigator assigned to the team. And so they had been working pre-pandemic, but now it's really been quite concentrated, and they've been doing all of the training remotely. And it's going quite well. Initially, when we started doing it, they really packed in the training, because I think that the concern was, we have these new folks, they don't have caseloads, we need to make sure that they're busy. And the feedback that we ended up getting was, this is really exhausting and overwhelming to be on Zoom, you know, for the better part of the day, and to be taking in all of this new information. So we've changed it up a bit in that we have we've spaced it out a bit. So it's usually at least a 3-month period of training. We actually send all of the materials to the new folks before they start. And we sprinkle in some cases so that we build their caseload a little bit by bit, so they have some context for the training. And that seems to be going better. You know, the reality is that the recruitment efforts in this pandemic have really been successful overall. We have managed to attract some really qualified and experienced folks, in particular in both the attorney and investigator ranks. We have filled all of our positions in San Francisco. And we did change it up a little bit, because we weren't attracting all of the applications that we really wanted to see in San Francisco. So we've opened our minds in this remote world, and we actually have filled, for example, an investigator position for San Francisco teams located in Los Angeles. So the investigator works physically in Los Angeles, but is assigned to a San Francisco team. This is not totally new. We've actually been doing that for the last about 1.5 years in another classification as well. And it's worked fine. And the reality is that whatever our world looks like on the other side of this pandemic, we know we're going to be doing more remote working, and we think that this will work. So we have some additional positions in Los Angeles that we're currently recruiting for. And those really are the results of doing promotions and also some retirements that we've had, which I'm going to talk about in just a moment. But, you know, so now we have these people, and we want to hold on to them. And that's clearly very important to us. And so I want to talk a little bit about some of the things that we've been doing in our office, and then sort of in conjunction with the bar as a whole. And it really starts even with just some small personal touches that I hope actually are meaningful in the end. And that is, for example, in the investigator and attorney positions, I personally call those applicants and make the offer to them and talk with them a little bit about the office and what they can expect in their first year. And prior to onboarding, and this is happening across the bar, the supervisor of the new staff is reaching out to the new staff to introduce themselves and welcome them to the team. In the first couple of weeks of new staff starting, I actually meet with them personally. This is something that I've been doing for the last couple of years. And of course, I used to do it in person, and now I'm doing it remotely. But it's really just an opportunity to say hello, get to know them a little bit, and to encourage them to communicate openly with their supervisor and in meeting with me, so that they know that they can always call on me, send an email, have a Zoom meeting. And I have also been in the last, since March, meeting with, in particular, investigator and attorney staff 90 days into their tenure with us. And that's really because I've been very concerned about the staff that we have been remotely onboarding. I really want to make sure that they feel connected. And I'm very mindful of the fact that these are people who don't already have established relationships in the office. So it's one thing for the rest of us to be doing remote working when we already know the team. But when these folks are starting remotely, the only real exposure they have is to their team members, their supervisor, and they're not getting a lot of exposure outside of that. And so I want to make sure that they're feeling connected and hear any feedback that they have. And that's been going well. Some of the feedback that that I've received, and so that we're actually taking a look at, is I think really in the investigator ranks in particular. I think some of the challenges for the new folks onboarding remotely is that they don't have the opportunity to sort of problem solve and ask questions and talk through cases just with their coworkers, again, because the only folks that they really see are their team members. They do have a mentor and their supervisor. Whereas if they were in the office, we have folks who sit near each other in cubicles. It's easy to turn and ask a question. You run into people in the lunchroom and you're able to sort of talk through things with people. And so we're really taking a look at our mentorship program. We do have a mentorship program, and we've had one for some time now for both attorneys and investigators. But in particular, we're really taking a look now at the investigator mentorship program so that we can see how we can better support people. And I'm hopeful that that those people in particular, the people who are working and onboarding remotely with us new, will benefit from changes and improvement we can make in the mentorship program. But some other things that we have been doing in terms of retention is we have what we call a first years group for both investigators and attorneys. We've had it for probably both of them for probably about 2 years now. And what that is we have volunteers in our office who lead these groups. So we have 2 attorneys in our office who lead the first year's attorneys groups, and we have 2 investigators who lead the investigator group. And it's literally what it sounds like. It's the people who are in their first year with us who come together at least on a monthly basis. And when they were in the office, they would have lunch. Sometimes we would buy lunch for them. Sometimes they would bring in their lunch. Now I think they're doing some semblance of that on Zoom. And they might just talk amongst themselves. The more seasoned people will field questions or raise topics. We also have speakers that come in. So for example, Donna has actually come to a couple of them to talk about the bar as a whole. We have other people in our office who are in different assignments who will talk with them. For example, from our non-attorney unauthorized practice of law team, they have gone and talked with them. So it's an opportunity to move forward as a cohort. Get to know people who are not just the people on your team, but the people sort of out there who are in the same boat as you are. And they have graduation ceremonies after the first year. When we were in the office, they would get a cake or something like that, and it was very festive. So I think that that's gone really well. We've had some really good feedback. Some of the other things that I think are really impactful when it comes to retention is for people to know what their path forward is when they join the office. And by that, I mean, if they're interested in promoting, how do they get there? What does that look like? And so some ways that we've been working on that is, it was very nice in this last negotiation that the MOU in the end has allowed us to do what we call promotions in place. And this is the first time since I've been here that we've had this ability. So it works with in the investigator ranks. So people who are investigator 1s have the ability to move forward to investigator 2, and that's without, applying and competing. And now also with our attorney ranks, we can promote in place deputy trial counsels to senior trial counsels. Before this mechanism, what we had to do is when we had an opening, we had to post for it. People had to put in their applications. We had to go through a, interview process, selection process. It was a bit of a competition that sometimes it wasn't terribly clear to the people on the outside looking in how and why certain selections were made. Also, sometimes people from the outside were brought in to those positions, and that undermined morale a bit. So what we've done around these promotions in place is that we have shared out competencies to the attorney staff so that they know these are the things that we're looking for, and it's competencies in their current position as well as the propensity for performing at the senior trial counsel level. And I'm happy to say that in October, we did our first 2 promotions in place. We had operational needs for 2 senior attorneys, and we were able to promote 2 of our deputy trial counsels internally. And I think that's really positive for morale. And I think that we will continue to do that in 2021 as our needs evolve. And the other thing that our office and the bar as a whole is doing is something called training and development positions. And these are positions where we have people who are in other classifications who might be interested in promoting, but don't necessarily have the entire skill set or experience of those other classifications. It gives them an opportunity to get a taste of what that work is, and we can get a view into how they might do in those positions. So we've done that with investigators, for example, and also paralegals. And we have some supervisor positions that we're currently doing that with. So attorney supervisors who are interested in promoting into the supervision ranks are serving for a 6-month term in temporary supervisory positions. And so I think that'll be really good too. It gives people, like I said, an opportunity to sort of grow and develop and build their resume, and gives us an opportunity to see how they might do in those positions. So overall, like I said, we've done well in terms of recruitment, and I think we've done well in retention. You know, the reality is that we have a very tenured staff in some of our classifications, and in particular in our investigator ranks. And as a result, not surprisingly, also with the new medical benefit that is being provided, we have seen some retirements of tenured staff this year. And we have a handful more coming at the end of December, which is usually when we see those kinds of retirements. In the challenges, then, you know, you're losing 20, 25, 30-year employees who have brought a lot to the office. And we're replacing them with folks that we have to get up and running. And while we are prepared to do that, and we are, like I said, successful in bringing people on, what we know about bringing on new people is that it really does take time for people to become full-fledged, you know, complete caseload carrying members of our office. It's not just the training, but it's the nuances of the work. And so, for example, in our attorney ranks, while we've definitely been able to bring on some folks who have some really great experience, and we don't have to teach them to be attorneys, which is great, they do have to learn the work, and the work looks really different. And so I really don't think that we're going to feel the full impact of those additional resources in our office that we've been able to add until well into 2021. But I do think that we are well on our way to getting there. So that is what I had for you today, and I'm happy to answer any questions that you might have.
All right, before we get to any questions, just want to thank Melanie and Steve for your leadership during this time. And when someone says unprecedented, definitely means unprecedented. So I really appreciate the responsiveness that you've taken with the staff to do the reorganizations that are necessary to address the inventory issues. And, you know, during our biweekly calls, in listening to Melanie and Steve's report, definitely thought it was good to get this information in front of RAD to see if RAD had any questions or concerns. You know, working with the unprecedented times as they were, or as they are, I just want to commend the staff of OCTC, our investigators. I know you all make significant sacrifices in working from home, and also having that flexibility in keeping up with your day-to-day duties and tasks, all while being constrained by the pressures of this pandemic. So I just want to commend all of our employees for the excellent work that you continue to do. And thank you, Melanie and Steve, for your leadership. So are there any questions or concerns from other RAD members? All right, and I would also just note that I thought it was important to have this presentation as it could inform a later discussion that we're going to have about the RAD work plan. So keep Melanie's words in mind when we get to that. So, all right, anything before we move on? Okay, seeing nothing, we will go on to the item C here under business, the Office of Professional Support and Client Protection. And we have Lori Meloch and Michelle Harmon presenting on that. So please share with us what you have for us. All right. Okay, welcome.
Hello. Good morning.
Good morning.
Thank you for having us. My name is Lori Meloch. I am the Program Director of the Office of Professional Support and Client Protection. The Office of Professional Support and Client Protection is the umbrella group for 3 offices of the State Bar. The Client Security Fund, the Office of Case Management and Supervision, and the Lawyer Assistance Program. And Michelle and I are going to give a presentation for you today about briefly what each office does and some updated statistics on where we are for the year. I'm lucky to work with excellent staff in all of these offices. Matt Zaywall is the supervising attorney of the Client Security Fund. Terry Goldade is the supervising attorney for case management and supervision. And Michelle Harmon is our supervisor of the Lawyer Assistance Program. Just to sort of streamline the proceedings today, I'll be presenting about CSF and probation, and then Michelle will talk to you about the mandatory Lawyer Assistance Program and the voluntary Lawyer Assistance Program. I'm sharing my screen. Hopefully everybody can see that. We have some materials for you to look at here. So I'll start with the Client Security Fund, just a brief overview. A lot of you know somewhat about the fund. It was established by Business and Professions Code 6140.5. CSF reimburses the losses caused by the dishonest conduct of California attorneys. There is a 5-member Client Security Fund Commission that has the sole and final authority to grant reimbursement on these applications. They delegate that authority and work with the counsel, including myself and our other counsel in the Client Security Fund, to administer the fund and process all of the applications that we receive. The commission is appointed by the board. There's 3 attorney members and 2 non-attorney members. Our basic requirements for the Client Security Fund, just briefly, are that the attorney must have received the money or property that the applicant is requesting to have reimbursed. We cannot reimburse for negligence or malpractice. It has to be money that the attorney actually received and wrongfully retained. So there has to be dishonest conduct there. It has to be an active California attorney who is acting in a professional capacity customary to the practice of law. Our maximum reimbursable amount is $100,000. And this is a discretionary fund. There's no right to reimbursement from the Client Security Fund. We have to have discipline or other limited qualifying event for regarding the status of the attorney for the Client Security Fund to be able to handle an application. The attorney can be deceased. There can be a judgment against the attorney, but most of our cases, we have discipline against the attorney. And that is what allows us to finally move forward with an application after it's been filed with us. The Client Security Fund is funded through the licensing fees. The active California attorneys pay $40 per year. The inactive licensees pay $10 per year. In 2020, we received an additional $40 per active attorney to help us on our inventory reduction program. During the years when we had attorneys involved in loan modification schemes, the inventory in the client security fund increased dramatically, and we did not have the funds available to reimburse all of the applications that would qualify. So an inventory had built up and we were handling them as we could each year. But we were lucky enough to get this additional funding so that we could try and really reduce that inventory as much as possible this year. And we've been working hard to do that. In recent years, we've resolved an average of about 1,500 applications per year and have provided reimbursement averaging about $7.3 million annually to the victims of attorney theft. And as you can see here, since its inception, the fund has reimbursed victims over $170 million. The goal of CSF has always been to try and reimburse within 12 months of the final discipline. So somebody might file with the client security fund at the same time they file their discipline complaint, but the fund can't move forward until that discipline requirement is met. So we monitor those pending cases, and then once the final discipline is final, and that means actually approved by the California Supreme Court, then we can move forward and assign it to one of our attorneys to prepare for review and processing. We'd had a history of timely distribution up until, again, as I mentioned before, the growth of the inventory that we had that was attributable to the loan modification crisis. And during those years, we went up to almost, I think at one point we had over 8,000 applications, where at one point we had been down to around 900. So there was a huge increase over a number of years. And we've been steadily working at that, getting those cases processed and reimbursed if they qualify. As I said, we got additional funds this year, so we've been able to really work towards handling that inventory. Right now, we get reports from our Office of Finance that tells us what the nominal value of our outstanding applications are. And as of the end of October, all of the amounts requested on the for the applications open equals about $40.5 million. Of course, we don't pay that. Not everybody who applies qualifies, and not everybody who applies qualifies for the full amount they're requesting. So what we do is we apply it. There's a 24-month rolling average that is tracked by our Office of Finance, and right now it's around 39% or so. So we apply that to the amount that is outstanding, and it looks like we have right now of the 40.5 million. If our average turns out to be true, it's about 15.9 million that will actually end up being reimbursed on these open applications.
Ms. Meloch, can I jump in with a question here? I apologize. I don't know if
Yes,
you're
of
taking
course.
it now or waiting till the end.
Go ahead.
That rolling average number is only an estimate. It's is it possible that we could pay out more than that 40% given the circumstances of a particular year? It's not a cap, correct?
Correct. Yeah, that's just an estimate to try and give us an idea of what we're looking at and plan. But some years it holds true and some years it's a little off. I will say, generally speaking, it's been pretty on point in terms of what we've been able to do. So that looks like it's probably will be about right, but it can change. We had with the loan modification cases, because we had so many cases that were one respondent attorney that had a large number of applicants against him. Those all, for the most part, if they could provide the proof and the circumstances were the same, a lot of those turned out to be reimbursable. That kind of at one point shifted it up so that it was more cases were being paid. There weren't as many balancing out on the deny side, but it seems that we're back to more normal circumstances, and this is holding probably to be true.
Great, thank you.
Excuse me. As you can see, our total inventory at the end of last year in October was 2,400 applications that were open, and this year we're down to 1,750. And that's even with the new cases coming in. So we've really been eating away at that inventory and getting through these cases so that we can get reimbursement to the people who need it. And if they don't qualify, let the people know why they don't qualify and they get their denial. For 2020, we have 12.8 million for distribution. In 2019, we had 6.9 million for distribution. So as you can see, that additional funding is really helping us to pay out more cases, or at least actually pay out as many cases as we can. A lot of the cases this year have been high dollar, so it might turn out that we're not paying as many as we thought, but there are a lot of high dollar cases that are being reimbursed. New applications are down this year. Year to date, we've only received 400 applications, whereas last year for the entire year, we received 750. I find it hard to believe we're going to get 350 more cases by the end of the year. So I think it's going to be a year where there's not as many new applications coming in. Probably for some of the reasons that Melanie was mentioning before, that people aren't able to get documentation and follow up on things. We're having that same issue here with the fund. And I'm wondering if that's, people have other things obviously that they're focusing on this year, and they might not just be getting to something like the Client Security Fund and pursuing something like that, even if they have had a problem with an attorney. So I guess we'll see what happens next year if things get to be a little bit more of a normal year. Through October of 2020, we've reimbursed 8.1 million so far on 668 applications. Our goal, as I said, is 12.8 million. We have over $4 million already out in process on applications that we've served, and that we are waiting to make its way all the way through the process. People have the right to do due process with the Client Security Fund. So we have to issue a legal decision, and then both parties have the right to object and request, and those items, if they do request, go to our Client Security Fund Commission for further review. So we give everyone their due process and handle all of the applications in a fair manner. And so that's why we can't just issue a decision and then immediately pay. We have to follow all of our procedures. And so that's why we still have a large amount outstanding, but I'm hoping that a good number of these will close by the end of the year. And if not, that in January, we'll be able to close out the rest and hopefully reimburse this amount that we have for reimbursement. We're finding, similar to, again, what Melanie said, it's taking longer for people to, if we need their proof of payment to the attorney to get back to us with their documents, they're having trouble maybe going to the bank and getting what they need, or even just, again, focusing on this issue when we write to them and ask them. And we do try to be consumer friendly. We try and help people through this process. So if they need more time, we give them more time to respond so that they can try to prove that they suffered the loss, and if we can help them, and then we try to reimburse them. We've resolved another 360 applications that did not qualify for reimbursement. So we've handled a large number of cases this year. Our goal this year is the most that ever has been paid out by the fund. So with everything going on, I'm really proud of our staff that we've managed to keep working on these cases and doing our best to provide the proof and write them up in the correct ways so that we can try and handle them appropriately and get them through the system, despite everything that's going on in the world. And so to have over $12 million out at this point, I think is a really big accomplishment for our staff. So that's what I have for you on the Client Security Fund. Before I move on to the Office of Case Management, Supervision, Probation, are there any more questions about the Client Security Fund? Great, thank you very much. So also under the Office of Professional Support and Client Protection is the Case Management and Supervision Office of Probation. Now, probation monitors disciplined respondents' compliance with ordered conditions. They can refer a respondent if the respondent does not comply with the terms of their probation. The Office of Probation started as a unit with the State Bar Court many years ago. At one point, it was part of the Office of the Chief Trial Counsel, and it became an independent office in 2003. The office is located in Los Angeles only, but it monitors all of the California attorneys who are on probation. The disciplined attorneys on probation are there pursuant to California Supreme Court orders. with stayed or actual suspension. That's one group that the Office of Probation monitors. We also monitor disciplined attorneys who are on reproval. Those are the cases where there's no stayed or actual suspension, and they are disciplined pursuant to the state bar court orders. The office also monitors compliance with Rule 9.20, which is the rule that requires attorneys to notify their clients and opposing counsel and other parties that they are being suspended or disbarred. So for Rule 9.20, the Office of Probation also monitors not only those on probation, but attorneys who are in ongoing conviction matters, resignations with charges pending, and attorneys who have been disbarred. And in some cases, the Office of Probation monitors attorneys who are in part of the alternative discipline program. Right now, for the Office of Probation, we're working on what we call our Attorney Supervision and Assistance Redesign Project. We're trying to move more towards an evidence-informed approach so that we can better tailor conditions to the respondents, and we're hoping that this will help reduce recidivism. We're looking to implement a risk assessment tool that can be used to determine which of the respondents might be at higher risk for recidivism and might need additional resources so that we can work with them to hopefully prevent them from getting discipline again and to protect the public that way. We're going to be looking at implementing case plans that will work with the respondent attorney on to help provide more tailored conditions to them based on their risk levels and try and address the needs of each of the respondents. And this could hopefully include if there's an attorney who has substance use issues or mental health issues, if we can refer them to appropriate experts or to our LAP program, which Michelle will talk about in a few minutes, that we can help them get the help that they need so that we're protecting the public and helping these respondents if we can. In implementing our new system, we're going to be training our staff, and we're going to be working on making sure that we look at issues of implicit bias and avoiding bias. And that's one of the main things that we're really keeping at the forefront as we create this new project, is to try and make sure that we don't build any bias into this system and that we're treating everybody fairly. So this is a big project, and it's going to involve a lot of change for the Office of Probation, and you'll be hearing more about that as we move forward. Are there any questions about the Office of Probation? Thank you very much. I'm going to turn over to Michelle. Oh, I do have some statistics for you. I'm sorry. These are the statistics for the Office of Probation. It shows that there are almost 500 cases open right now. There's a staff of 5 probation case specialists. So each probation case specialist is responsible for approximately 100 cases, and they work really hard on that. They're all supervised by one attorney, Terry Goldade, who works with all of them to keep everything running. So they all work really hard and efficiently to keep all this going for us. And now we can move on to Lawyer Assistance Program. Michelle, why don't you go ahead and talk about the LAP?
Thanks. Sorry, thanks, Lori. So as you can see here, our mission, of course, is to enhance public protection by supporting the mental health and the recovery process of law students, bar applicants. Current, former attorneys are all eligible. And right here on the first slide, I of course want to emphasize, because our #1 question is always about confidentiality. And our program is entirely confidential, so attorneys or law students, applicants who might contact the program do not have to worry about anything they tell us itself leading to discipline. However, you'll hear when we talk about monitoring that that many attorneys do come to us because of their discipline and come to us for the professional monitoring aspect as a mitigation for their discipline, in which case they sign a release of information so we can share information about their process with state bar court or with probation. So our program is overseen by our Lawyer Assistance Program Oversight Committee, which is a 12-member subcommittee. 6 of those members are appointed by the state bar. We have some mental health professionals, a physician who's experienced in mental health and recovery field. We have a representative from a nonprofit. There's a long description of the nonprofit, but the other bar members qualify for that. So we have a representative from the other bar and a couple of attorneys and attorneys in recovery. So Lori, will you go to the next slide, please? So this is an overview of what we offer. Outreach and education, we now have a staff member who is dedicated to our outreach and education, who has been really dedicated and done a lot of work towards increasing our social media presence, working with the Office of Communication to have LAP-related posts on our social media. Of course, around March, April, we had a lot of cancellations of presentations that she had scheduled, and she was really on top of getting the technology together and rescheduling a lot of them as virtual presentations. So we've been able to do 55 presentations this year already, which has been, I think, more than we expected when people started canceling in the spring. And those are MCLE presentations. They're to law firms and bar associations, and then also some law schools and presentations that are tailored towards law students. I'll skip down to the bottom, actually, the transition assistance service, because that's one of our less known services. All the people who are eligible for our program are also eligible for 2 free career counseling sessions and individual counseling sessions. So we can find therapists in the person's area that we are contracted with and cover the first 2 sessions, and then they can continue with the individual therapy on their own. The career counseling is extremely popular, has gotten more popular towards the end of the summer, coming into the fall. And those are career counselors who are very experienced in working with attorneys and finding other things that people can do with a law degree if they don't want to practice law anymore, or how to change to working in other parts of the law if they want to change what they're doing in their careers, and also working with law students who are just getting started. And we have had 136 people so far this year use the transition assistance service. We then have our more extensive lawyer assistance program. The first part of that is our assessment, the orientation and assessment period, which all of our the case managers are called clinical rehabilitation coordinators in the program. They're all licensed clinicians. They will conduct an assessment. They'll talk to people about their history with substances, mental health history, some family history, physical history, and come up with some recommendations to support the attorney in their recovery process, and then make referrals. We have an LAP support group, which is really the most unique thing that we offer that's very popular. And it is all people in the program, so it's all attorneys or law students who can talk about whatever issues that are going on with them. They're generally not talking about law, though, so that's the part that people find to be really interesting and supportive for them, to be able to have other people who are going through similar things in life, but it's not like a case review, and they're just talking about their recovery process or their stressors. And those groups are also led by licensed clinicians in case we have any emergencies or issues with people's mental health that they need to deal with. And so new enrollees in the program are also eligible for 3 free support groups. And then after that, there's a fee for them to continue in either the monitored or support program. So in monitoring is basically what I had said before, is that we will have the person sign a release of information so that we can monitor their compliance with our recommendations and then report back on that to whoever we need to. Sometimes we'll have employers refer employees who have had problems at work that they know are related to mental health or substance use issues. And then we can report back to the employer or to the state bar court or probation or the Office of Admissions if it's a moral character referral. And then the support program is, we provide the exact same services and the same support. Our LAP support groups, I don't think I mentioned, are also really small. We keep them under 10, it's usually 8 to 10 people. So it's really an intimate group, and they can provide a lot of, they get to really know each other and form relationships in that group. Will you go to the next slide, please? Thanks. So regarding the monitoring, when the person meets with our clinical rehabilitation coordinator, they make up a monitoring plan that also will get reviewed by our clinical team. And it could include recommendations. These are some examples of any of these things. So going to the LAP group, abstinence-based self-help groups. So that would be like Alcoholics Anonymous or Narcotics Anonymous, or it could be a depression self-help group, psychological testing if we need to get further evaluation, psychiatric medication management, therapy. Of course, we're generally recommending abstinence for everybody in the program. If somebody's in recovery, of course, abstinence is obvious. But even for people who are there for mental health issues, we will often recommend it because it would be alcohol even would be contraindicated with many of the medications people would be taking. We might recommend a treatment program and the biological fluid testing. That has been something that has evolved this year in a really interesting way, I think, because we generally used to do urine testing across the board, but then as COVID became more of a problem, people, of course, did not want to get exposed by going to the collection sites where they had to give their urine samples. And the contractor that we use for our fluid testing made available at-home oral fluid tests. So people can now test from home. They get a kit, so it's all tracked. They do this on video with somebody watching to make sure they put the stickers on it properly and seal things in the pouches, and do the collection on a video screen, so people don't even have to leave their house. And then, of course, we also have some education that we either provide and or require on issues that brought people to the program. Next slide, please. So here's some of our statistics. We had 138 participants last week when we did this slide. It's still similar now. And one of our metrics that we report on to management is regarding our satisfaction survey. This was something that was put in place last year in order to try and gauge whether we're meeting the needs of the people in the program. And so our goal was to have at least 80% of participants respond that they either agree or strongly agree that the information and services we provide effectively and appropriately address their goals, and at least 80% overall are satisfied with the LAP experience. And we thought that 80% would be challenging because, of course, the people who choose to answer the surveys often are the people who want to complain, and we do have a lot of people who are not voluntarily in the program. They're here because they're referred by admissions as part of their moral character process or discipline, like I said. But we have really been surpassing it. As you can see, this last quarter it was 94% and 90% respectively agreed or strongly agreed in those areas. And then about our presentations, like I mentioned, we've done 55 presentations. Those 12 live were at the beginning of the year. Law schools, government agencies, bar associations, and law firms. And what I didn't have on the slide, which I will mention just briefly about our funding, is that we had a funding holiday for 2020, but will be reinstated for 2021, that we are funded by $5 from every inactive attorney and $10 from active attorneys. And then $1 of the $10 that we collect is sent to the other bar per last year's fee bill. So this, let's see, 2020, 2019 was the first year of that. So we're also working really closely with the other bar to try and coordinate our outreach efforts and promote each other's work. And like I mentioned, there's a member of the other bar on our oversight committee as well. Any comments or questions?
All right, doesn't sound like there's any. So, I think that the Client Security Fund is one of the, one of the best things that the bar does. We step in and try and put victims back in the place they were prior to that attorney committing misconduct. And I think that you and your team can be exceptionally proud of the work that you do and the work that the state bar does to help victims in situations like this. And then also just talking about the Lawyers Assistance Program, I think in the midst of this pandemic, this message is all the more relevant and all the more needed. So thank you to your team for getting that out, getting that message out, and helping people confront those life-controlling addictions. So well done. Thank you for the presentation. And unless there's anything else, we'll go ahead and excuse you guys.
Thank you. Thank you very much.
All right, and so we'll move on to our last agenda item, and that is discussion of the work plan. And hearing the presentation about CSF, and then LAP, probation. We heard a presentation from Melanie. I wanted to be able to give the board members just a good broad overview of what we as RAD are charged with overseeing here at the State Bar. And so obviously Office of Chief Trial Counsel gets a lot of top billing, a lot of our time, but that should not diminish from the other important things that we have going on, especially in the probation department with the redesign project. Mark Broughton and myself work with staff on that, and we've had some pretty good discussions about current trends and discipline trends, evidence-based practices. And so a lot of those things I think really inform a lot of the continuing work at the State Bar to make sure that we're protecting the public, but also avoiding any sort of implicit or explicit bias. So this time is meant as a discussion of the work plan that we had through 2020, and then anything that members would like to see carried over into 2021. I think we're going to be finalizing the work plan at the January planning meeting. And so this work today will go to help inform that discussion, but I look forward to continuing this discussion throughout the year, and then also especially there at January. So I think maybe the best way to go about this is to, does everybody have a copy of the work plan from 2020? It should have been, if you can, just pull it up. It was sent out by Lisa, I think last week in preparation for today's meeting, but I just wanted to go through briefly so we stay on track line by line, and see if anybody has any comments or strong objections or strong, like, yes, let's continue to do that. So starting with the first one, discipline system statistical report. This is the bi-monthly report that includes the discipline system metrics and a bunch of different data points. And as to this, this discussion item, are any members of RAD wanting any other types of data points, presentation of data, any strong feelings one way or the other?
Lisa, maybe you can share your screen so we can all be following along.
Yes.
Oh, there we go. Perfect.
Okay.
Right, so as you can see, this is a ongoing agenda item. And so I would imagine that it's going to continue on into 2021.
Yes.
And so do any members of RAD have additional comment on this, things they'd like to see in 2021 for us to improve? I'm going to take Juan's silence as absolute support for this item. So, all right. Okay, we'll go on to the ADR. Statutorily, we are required to present this to the legislators. So this is obviously going to stay on for 2021. Any member wish to add any elements to our work plan to effectively put together the ADR, to communicate with members of RAD about any issues? Are there any concerns at this point? Okay. All right, seeing none.
Brandon,
Oh,
maybe
yes, Donna.
just for new members of RAD, just to let them know that due to the timing of when we have to pull together the annual discipline report, the close of getting all of the data together after the close of the calendar year, we often find ourselves having a sort of special off-cycle meeting of RAD to review the draft report. to make sure it is ready to go to legislature. So just something to think about, that's something that may get scheduled as we get closer to March.
All right, yes, thanks for the reminder. All right, any other comments on the ADR? All right, moving on to the performance review of the Chief Trial Counsel. And again, this is one of the most important aspects of RAD, is monitoring our Chief Trial Counsel and the Chief Trial Counsel's performance, and then making recommendations as to ways that the Office of Chief Trial Counsel could be improved. So this will continue on in 2021, but any changes that RAD would like to see?
So
All
Brandon,
right, seeing none. Oh, yeah.
Brandon, I would note there are two important pieces of this. One is sort of RAD's ongoing review of the performance of OCTC, and through that, the performance of the Chief Trial Counsel, him or herself. This particular item, as I'm reading it, referred specifically to the annual performance evaluation conducted of the Chief Trial Counsel, which was done in June of this year, July of this year, I apologize. One of the things that we may be, just sort of to put this on your radar, one of the things that we may be sort of thinking about as we move forward, there are three positions for which we do these full 360-degree reviews, the Chief Trial Counsel being one of them. And they are, per the board book, scheduled to be done annually. Being that RAD does evaluate the performance of the Chief Trial Counsel through other mechanisms throughout the year, and that the work of a 360 review is fairly in-depth and takes a fair amount of time, we may want to consider for this position and potentially the other positions in the board book, changing the cycle for that formal performance review to an every other year cycle. But absolutely, RAD will continue to be monitoring the performance of OCTC and through it, the Chief Trial Counsel throughout the year.
Yes, I would also echo the tremendous amount of work that goes into that. And I know, Donna, you took on a majority of that extra work. So in addition to everything else that you are doing here at the bar. So yeah, that's certainly something that we can discuss further, unless anybody wants to not do that. All right. Reports by entities within RAD's purview. These, you heard presentations from a couple of the different entities today, and when we set this in place, I think 2020 was the first year that we did kind of a rotating schedule of these entities. We wanted to give new board members and then also board members who've been on the board for a while, just a refresher as to the various entities, and then a overview of some of the trends that we're seeing in those entities. Have people found this rotating schedule to be helpful? We used to do it like every single RAD meeting, we had every single entity report. Moving on to the rotating, has it been a better use of time? Do people want that consistent update? Are there any strong feelings one way or the other? All right. Well, we can continue to discuss this. I do like the rotating aspect of this, of the presentation. So I think it's good to keep these entities at the forefront. Going down to ADR messaging and marketing. And this really centers on the way the ADR is effectively being reported and whether it accurately reflects the work of the State Bar. So this continues to, again, be at the forefront of our attention to make sure that the legislator is appropriately advised of the activities of the Office of Chief Trial Counsel. Any thoughts on this agenda item? I think it should definitely continue into 2021, and we can fine tune any aspects of that. We'll go down to discussion of OCTC hiring and retention, and you just heard from Melanie about this. Any strong objection to continuing this on into 2021. All right, if we go on to the next page.
I'm sorry, here we go.
All right, so this top item, conduct analyses that will inform understanding of fairness in the discipline system. This really, I think, goes to the heart of what the ad hoc commission is going to be reviewing and talking about. Now, I think, and Donna, correct me if I'm wrong, so the ad hoc is going to be reporting to the full board of trustees and not to RAD initially, is that correct?
I think that's the way we've been thinking about it. Certainly, there's an opportunity for discussion of that at the full board meeting that follows. But that was how we had, I think, initially envisioned it.
Okay. So is this something that we should maintain on the work plan then going into 2021? My sense is that RAD oversees OCTC, and we should know what's going on in our own shop, and then also be best designed to inform the ad hoc working group of trends, and really for us to keep our just keep the data really at the forefront of our attention here at RAD. So any strong feelings one way or the other about keeping this item going on into 2021?
I would certainly argue that, I would hope the committee would want to keep it on the agenda. I agree with you, Brandon. The creation of the ad hoc commission on the discipline system is an incredibly important thing that we're doing, but is not in any way intended to have RAD abdicate its responsibility over the discipline system, and understanding what's going on and helping direct some of that. That research is an important role for RAD to continue to play.
Absolutely.
Yeah.
All right. Oh yeah, Sean.
Yeah, I think you raised good points, and I think once the commission is up and running, it might make sense for leadership of that commission to come and speak to RAD from time to time, and give ongoing updates and make sure there's coordination.
Yep. Excellent. Yep. I like it. All right. Any other thoughts on this item? All right. Going down to the second to last, computational logic model. This was something that we had looked at on whether we were going to take on a system that would evaluate possible algorithmic processes for identifying online complaints. It's my understanding that we have decided not to pursue this. And so I don't think that we need to keep this on the agenda or on the work plan unless there's any strong feelings one way or the other.
No, I agree, Brandon. I think it should be removed.
All right. Any other thoughts on this? All right, last item, study recommendations made in light of Farkas report on disparities in the discipline system. So I would argue that this absolutely should remain in the 2020 work plan, 2021 work plan, and that the chair and vice chair of RAD continue to work closely with OCTC and State Bar Court in the implementation of the Professor Robertson recommendations. So any strong feelings one way or the other?
We have
Just-
other
just
reports
one minor-
now other than just the Farkas report, don't we, Brandon?
Oh, sorry. So what was that again, Mark?
Yeah, we have other reports now. For example, one that I reviewed yesterday concerning the lowering of the cut score, that type of thing. So we have other reports other than just the Farkas report. Do we want to just limit it to that Farkas report, or to say something effective reviewing all the other reports with respect to that issue?
Yeah, I think if there's a nexus between the Farkas report findings, then there's certainly an argument that it should be discussed by RAD, and that RAD should take the lead in, discussing those findings. So, and then where to go. So unless there's a strong sentiment that this should be handled by the full board, I think RAD can certainly continue to work on it. Okay, excellent point, Mark. All right, any other thoughts on new agenda items for the work plan?
Brandon, this is Ruben. Can we go back to that last bullet point on the FARCUS recommendations?
Yes.
Just sort of a minor technical nit maybe, but I noticed that on this column that says status, that it's completed, that we've essentially finished studying those recommendations. And that may be true because now I think we're moving to a new phase, right? Either implementation or further analysis. So either I think we should either change the completed moniker to ongoing, or maybe change the item description itself.
So we could list that the implementation of potential reforms, and that would, I think, definitely be listed as ongoing. Is that what you had in mind?
Yeah, except for, again, maybe a minor technical nit, but implementation might imply that we are automatically agreeing with everything that's in that report, and I can't recall at the moment whether that's the case.
No, it's a point well taken. There are certainly things that we move to the front of the list as far as reforms that we are going to make immediately. Some require a continued study, and the ad hoc commission, I think, is going to also be involved in that monitoring. So I think we can come up with language that captures things that we've taken on and things that we continue to study and determine their efficacy.
Great, thanks.
All right, any other thoughts? Oh, Arnie, I think you're on mute there.
Yeah, I was. I appreciate it. I just had a quick question, and that is, being new to all this, how dynamic is the 2021 work plan? As you know, we gain sort of new information or other things sort of potentially may come to our plate. Do we have some sort of flexibility with this? Or would we revisit it, quarterly? Or just wondering how dynamic the work plan is.
Yeah, so I don't think that there's any sort of static energy that's going to constrain us changing our work plan. I think obviously consistency is good, but if something comes up, let's say the ad hoc commission makes a recommendation that's in a new direction, I think that's certainly something that we can put back on the RAD agenda. If it's something that requires immediate attention, the chair and vice chair of RAD are in close contact with staff, and we can work, I think, really within the flexibility of the work plan to make whatever changes or refer things out for further study. But then actually changing the work plan, we can bring up at our bi-monthly meetings. And then if a special meeting is necessary, if it's going to be such a drastic change to the work plan, then that's certainly something that we can take up.
Very good. Thank you.
All right. Mindful of the time, any other thoughts or concerns? All right. We will now conclude the open agenda for the Regulation and Discipline Committee, and we're now going to go into closed session pursuant to Government Code Section 11126 sub C sub 2. And so I think we should all have received the link for the closed session. So go ahead and close out of this Zoom call, and then we will reconvene back into closed session on that new link. So we'll see you on the other side.
Check your email.
Adjourn the RAD meeting.
Terrific, thank you. And
all right, please